Hi, I'm Cal Barron and welcome to our WK Goodman's Legal Thinking podcast. When someone experiences a complex, life-changing injury, changes to the way they live on a day-to-day basis have to be altered. But how do they adapt and what adaptations do they need to make this work? Joining me today are three members of our WK Goodman's team to talk about that. I would like to welcome partner Louise Nettle from the Compensation Protection team, Elizabeth Cully, a senior associate in our disputes resolution team who looks after construction matters, and Adam Clapp, a senior associate in our dispute resolution team as well. Welcome all three.
Hi. Thank you.
Louise, I'd like to start with you if that's okay. Adaptations, on a very broad level, what are they and who needs them?
So I suppose, the starting point really for us is who our client is. And usually they are an adult or a child who has suffered, quite a catastrophic either brain injury or clinical negligence. And so part of that litigation claim will include a provision for a house to be purchased and for it to be adapted in order to meet that client's need. Usually there's, it's quite a big sort of pot of money. And so we go out usually in the area where the client's currently living, find suitable accommodation, and usually it's a plot, something that's big enough for us to extend, or, we're looking for something that is going to be able to be adapted. So we're not looking for listed Cotswold properties or anything like that. We're looking for pretty bog standard properties where we can either make it bigger and also rejig the inside. So once we've bought that house, we usually instruct an architect at that stage to draw up some plans and get planning permission for the ideas of what they're going to do. And once we've got planning, we then bring in Lizzie to look at sort of the legality behind the contracts and getting the contractors on board as well.
Absolutely. So in terms of a practical sense, these adaptations, what are some of the more common ones that you experience or you see? So level thresholds, wide doors, turning sort of circles for wheelchairs, level access, so usually everything on one floor. What we try to do is make sure that our client is able to access the whole house because it's their house, but sometimes we'll have an upper story, an upper level, and then perhaps the family might have their space up there. So we're looking at really a big bedroom and a bathroom, a wet room that they can use, a therapy room, usually, some living space, kitchen. So it might be that, that particular client is able to do, some cooking, but they'll need, kitchen sort of rise and fall worktops and, so all those sorts of things. And then, being able to go outside, use the garden, those sorts of things. Absolutely. And how are these adaptations normally kind of defined? Is that in conjunction with, the client, their family, their medical needs? How is that list kind of drawn up essentially?
So during the litigation process, the litigator will appoint what's known as an accommodation expert, and they will go look at sort of condition. They'll look at other reports. They'll speak to sort of occupational therapists and physiotherapists, assisted technology experts, and then they will sort of see where that client is living currently, usually in sort of local authority accommodation that might have been adapted, like just a stair lift or a ramp, and then they will make suggestions sort of based on the area that client's living in terms of the proposals for what is a suitable property and what needs to happen, I suppose, within it in order to make it sort of fit for purpose for that client.
Are there normally any challenges that you see when trying to find kind of land or a suitable building? I know that you said you try and keep it close to where the client lives, where they're familiar.
Are there challenging areas, locations where that may be a bit more of a problem?
Yeah, there's very few bungalows. No one wants a bungalow. So we've had to be sort of quite creative, I suppose, in the way that we've purchased properties and sort of adapted them. So we have, in a couple of cases, sort of bought two properties together and knocked through, so that we've got one property which has got more, a bigger garden and a bigger sort of, just a bigger house that we've able to sort of put together, or a plot of land. So we've got cases at the moment where we've done sort of, we've got that plot. And then, there might be just a tiny house on it. And so they've sort of, taken that to the floor and then just started from scratch. So, yeah, but it's quite difficult to sort of try and find suitable properties in areas where particularly, clients, families and friends are, because relocating them to another area is going to make them feel sort of quite isolated, particularly if it's children, making sure that they're near their schools and things like that, and family members. So, yeah, it is difficult, but usually we use property finding experts who will go out, but with Rightmove, it's pretty easy for us to do that ourselves. So.
No, I imagine the process is potentially a lot easier than it would have been 30 years ago.
Pop a paralegal on the laptop and they'll go through and put the criteria in.
Lizzie, I'd like to throw to you next, if that's all right. In regards to kind of getting these adaptations, I imagine a lot of these due to the specific needs of clients and what they require. That's going to make legal contractual agreements with contractors probably a little bit more difficult than normal. Is that right in saying?
Yeah, so I'd say the main difficulty we have is that, normally if the trustees weren't involved and this wasn't, being done on behalf of Louise and her team and the deputies, then it would just be an individual person or an individual family building a house, extending a house, adapting a house. And so the type of contractors that will tender for those types of works expect it to be done on that relationship where it's like a consumer commercial relationship. Whereas as soon as the trustees are involved and as deputies with their obligations to the Court of Protection, which they need to discharge, they're treated differently under the CDM regs, which is health and safety, because they're a commercial client rather than a homeowner. So there's kind of all of these different factors they've got to think about, what's going to happen in the future with the property. Because of those reasons, we need to look at it as a commercial relationship rather than a consumer commercial relationship. And so the contracts that we tend to use are industry standard. So we use a lot of JCT contracts. But we use the commercial side of them, which is the minor works or the intermediate or the design and build. Whereas if it was a homeowner situation and you were just, Joe Bloggs doing extensions on your house, there's a JCT homeowners contract, which is very simple, kind of based on you doing a 20K extension or something. So our kind of starting point when we go into a lot of these conversations, when I get involved, and I know, to be fair, I'd say 9 out of 10 times it's fine. But every now and then you'll get a contractor kind of turn around and say, hang on, why am I having to sign this? Is completely different to if I thought I was just doing adaptations projects or for, just a regular consumer. So that kind of starting point can be a bit difficult. But yeah, it basically all comes down to the role that the trustees and the deputies have in their relationship with the protected person who's going to benefit from the property. And then kind of my role and our team's role is to make sure everything's written down in paper, protect that, and just have as much, I guess, dispute avoidance up front as possible.
Absolutely. And I imagine that point you make around the fact that it's kind of a commercial relationship is really interesting, as that's probably not what many would expect when it comes to kind of fitting a house out properly. How does that impact, I guess, the cost implications to begin with? Is it a bit more for that kind of commercial element, or is it relatively similar when it comes to agreements?
In terms of the level of my involvement or the actual overall value of the
probably
project?
in regards to the overall value. So I imagine it's if a commercial contractor is looking into it to do it under a commercial purpose.
It shouldn't change the construction cost much, to be honest. It's more just the kind of the front end agreements and the expectations. I mean, I guess thinking about it commercially, if I was acting for the contractor, I'd probably turn around and say, hang on, these guys are going to be a lot more on you. You know, variations have to be done properly. One of the big differences between being a commercial client versus a consumer client is that also the Construction Act will apply with its payment terms. And there's a very strict regime of payment terms where you have to submit applications by a certain time, submit notices. And if you don't submit notices, there's a big implications. So if I was acting for the contractor and I turned around and said, hang on, this is now a commercial client, it's being led by the trustees, you're going to have to follow all of these processes. You know, technically that's more admin, and therefore you might want to slightly change your fee. But generally, no, I'd expect the project to be, you know, exactly the same. If anything, it should really end up, I'd say from my perspective, seeing how different projects are run, coming in lower than if you were just a general consumer client, because things are being ran properly and you've got architects and contract administrators on side who are going to question invoices, make sure everything's being done properly. It's almost more streamlined, and you'll have more control and more visibility over the cost of the construction project if you're kind of, just keeping up to date and keeping on top of things from the beginning. Whereas if you were a general homeowner consumer, you might just, you know, agree on a handshake that you want the contractor to do X, Y, and Z. And then suddenly 6 months down the line, you don't have a real program. You can't turn around and say, you said you were going to do X, Y, and Z by this time. You don't have the expertise to say, those windows aren't right, or this isn't right, or that flooring isn't right. Whereas, the way this is all set up is, very much so giving that leverage, I think, to have those conversations and keep everything on track.
I think it's probably important to note as well that, you know, when we're instructing architects, we're not instructing people that are not used to dealing with these types of projects. So, you know, they really need to be experts in their sort of field as well. And they will tend to tender to contractors who they've used before. I mean, we have, you know, we do sometimes, I guess, have contractors that will come back and say, well, actually, you know, this is going to be, like Lizzie said, a lot more difficult because you tend to have like special conditions, don't you, that you put in. Yeah. So I guess maybe their sort of heckles are raised maybe at that point. But so we don't just, you know, do a quick Google search of architects in the area. We have sort of companies that we use regularly, so they should be used to all that process. And usually we tend to at the tender stage, I guess, when the architects are sending those tenders out, and sometimes we'll put those special conditions within the tender pack, so they almost know like what they're not letting themselves in for, but you know what they're sort of signing up to, I guess, at that point. So
And it works the other way around. If you're doing it at that tender stage, then when you have contractors pull out because it's not the type of work they're used to doing, and they're not going to be used to, you know, the reporting requirements and the payment notices and stuff, then it's kind of good for the trustees that they pull out of the race. Yeah. Because at the end of the day, you know, we can sign all of the contracts, we can get everything set up, but you need to have a team that you can rely on and are going to operate in the way that you want them to operate.
But this is where things go wrong, where you don't...
we need to get Adam involved.
You don't have exactly. Yeah.
Just in time.
Well, you don't front load the aspect of things in the right manner. Yeah. Things fall apart at a later date inevitably because they, you know, got some contractors going to say, well, this wasn't flagged to me initially. Yeah. This wasn't raised. I haven't signed up to these terms. I wasn't aware of this. So that's when issues arise, which you want to obviously avoid. Hence, Lizzie being involved from an early stage in these sort of matters to try and front load and avoid any disputes happening. Or if disputes happen eventually down the road, at least you've got a concrete structure to go from in terms of actually trying to resolve that dispute and knowing who's gone wrong and where. You're not relying on the oral evidence of different parties as to who said what and when, and then it's one party's word against another. It's, have you followed the correct procedure? Have you got your notices in on time? If it's a no, then you go down this route. If it's a yes, you go down that route. So it just makes it a lot more cut and dry and easy to deal with.
Adam, I was going to ask on that actually, in terms of when something does go wrong, what is that process and how does that look like? So in terms of if we're obviously acting for, you know, a trustee on behalf of this client, when you have a contractor coming to you saying, oh, well, I wasn't made aware of this, or this isn't, you know, what we promised, how do you kind of navigate that challenge?
Well, I mean, there's firstly, nobody wants to see me at any point in these types of disputes because
you're not
the reality of the situation is you want the compensation fund that the vulnerable person's got to go in the right places, to go to towards the project to get the best possible build they can to suit their needs. In these types of disputes, it can be a myriad of different things, to be perfectly honest. It could be defects. You could have a contractor that's trying to vary the terms of the agreement and it's not agreed by the necessary scope. You could have them not sticking to the program of the work, so a delay. So a few of them I'm dealing with at the moment. For instance, you've got contractor that's not done the right things in terms of the actual works themselves. They've not been adapted the way they should be. People have tried to vary the contracts and add on costs at a later date, when the reality is that should have been agreed or that was included within the initial scope of works. So there then gets a contract administrator come in and say, no, that was in the original scope. You can't use that as a valid variation. So a lot of it is, if you've got the contract sorted and you've got Lizzie involved and got those contracts and you've got the right mechanisms in place, you're able to separate those disputes out during the project, because you don't want the nuclear option of everyone's fallen out, termination of the contract, we've got to start from scratch. That's increased cost for everyone. So you want a mechanism where you've got the Construction Act that applies, and you separate out, for instance, the interim payment applications, where you're saying, I've done X amount of work in this monthly period. The contract administrator or the architect comes in and says, yes or no, I certify this amount of works. If there's a dispute on that, that can be separated out and the project can continue. So that's the primary reason that I would get involved in those sort of things. But there's defects claims after the fact. There's final account sort of claims where you're arguing over the sum of the final value of the works, snagging, all sorts of, like I say, liquidated damages, delays and things like that. So there's a myriad of different disputes that can go wrong in these types of projects, as similar to other projects as well.
Absolutely. And I imagine a lot of that is, as you said, kind of getting that process clear from the start of where things need to sit or how they're addressed. Lizzie, you did mention kind of having special conditions that are included in regards to some of these contracts. What type of conditions do these normally look like? How are there some common special conditions, for lack of a better term?
There is, to use the phrase, oh no, hang on, I'll start with, so JCT contracts, which we tend to use, are it's well known in the industry that they're drafted in favour of contractors, and a lot of the provisions in them is to protect contractors. So it's very common practice for people who are acting for the employer of the works, so in this scenario, the trustees, is to slightly amend some of those conditions in order to rebalance the risk allocation so that it's generally fairer, to cover any specifics to do with the site and the project and their requirements, and in the trustees' case, I guess, to discharge their general obligations to the Court of Protection. In terms of the specifics, there is what we would call institutionally acceptable employer-led amendments within the industry. So that'll cover just some straightforward things like extending the payment deadlines for making payment. So from the trustees' perspectives, this is particularly valuable because obviously they will have to apply or go through your own internal processes to get money to pay an invoice for a contractor. So the longer the better. It's not just a case of you being, a company with it in your immediate bank account. And also they need to rely on the contract administrator to go on site, check that everything has been done. And, depending on locations and logistics, because as Louise said, there's a smaller group of architects and contract administrators who they trust for these types of works. It's better to have a longer period for that to happen. So instead of 14 days, you have 28 days. So that's just kind of like a generic change. Other things off the top of my head, I guess site condition, depending on the particular site. So if it hasn't been demolished, you want them to be aware of certain things and the contractor to take responsibility for that. Also, if there's a property right next door, there's all the party wall issues and those kind of agreements and awards you want them to be aware of. Anything specific from a planning perspective. Yeah, that's kind of all I can think of at the top of my head right now. But yeah, there's a couple of issues and we basically deal with them in a schedule of amendments to the JCT contracts.
Absolutely. I imagine it's a lot to cover for any client. Louise, when it comes to kind of working with those clients and going through those options, is it a lot easier having a lot of that expertise about anything from that kind of, construction, what's needed in terms of getting those adaptations through and making sure it all works at above board, to having those disputes, if anything does go wrong, having that all under one kind of roof, one house, does that make it a lot easier kind of navigating this with the client on behalf of them?
Yeah, we don't tend to get our client, I guess, is Withy King Trustees Limited, who are appointed as deputy or trustee for that protected party. So Lizzie's client, I guess, is WKTL, so Withy King Trustees Limited. So we don't tend to get, the family involved in that sort of contractual side. But Lizzie often gets an email from me entitled "Help!" exclamation mark. So it's great that we've got it all under one roof. I've worked in other firms where they don't have a construction team, and it's it is a minefield, isn't it? Really, and we're signing up to it, and as professionals, we have a sort of higher level of duty of care, and so it's great that we've got sort of Lizzie and her team and Adam on board, an email or a telephone call away that we can get them involved if we need to.
Well, dare I say, it's someone that's trusted. Yeah. So that you've got an in-house team that you can give good, solid advice that you can rely upon. So you don't have to go into sort of the nitty-gritty, the schedule amendments of stuff. It's what you expect and should be done in those certain circumstances.
Absolutely. I imagine a lot of these, clients, for lack of a better term, or people that require these adaptations, the last thing they're wanting is going through that minefield of correcting defects and making sure that the contractors are doing what they've agreed to do. So having that kind of relationship not only with yourself but also that access to a wider team is something that just provides a nice peace of mind for them more than anything else.
Yeah, absolutely. And we do have a lot of clients who will have a family member who is a builder that wants to do the work, and so having that sort of level of expertise behind us where we can sort of navigate those sort of potential issues, because although it would be, I'm sure, a lot cheaper for a family member to do the building work, it's such a sort of conflict of interest in terms of getting family members involved and things like that. And also it's not the same level and the same sort of standard of work. There's a higher duty of care there really that the contractor and the architects owe to our client as well. So it's really great having Lizzie and Adam.
Certainly screams red flag from my perspective. Any sort of family involvement extra.
Yeah.
So.
I've got an uncle who's a builder.
Yeah, exactly.
Yeah, so
specialists are key. That's one additional thing as well with architects. If you get the wrong party involved, and from the outset, and again, you're dealing with a similar sort of matter at the moment, that if you get an architect that's not experienced in these types of projects, they can quickly escalate. Or if it's delegated down, for instance, to a junior that doesn't really know what they're doing and it's not spotted at an early stage, things are delayed, costs increase, and you end up having to start from scratch with a new architect and starting the tender process all over again, when some process that should take 4 to 6 months ends up taking 18, something's going wrong. But again, having the right appointments in place so that you can terminate at will those sorts of contracts and move on and take the nuclear option when you need to without any sort of encumbrance or having to meet a higher burden of proof or make sure that they've met the necessary terms to terminate the contract. Just having that ability to say, no, you've not done your job properly, that's it, terminate it will.
It's flexibility, isn't it?
It's flexibility, exactly that.
I think, because of the sums of money involved, it's important for those architects and those contractors to understand that, this isn't a lottery win. This is money that's been awarded to put that client sort of back in the position that they would have been if they hadn't had that disability. So, or the injury. So, it's really important that we have got people on board on those projects that are able to understand that, I guess, not just sort of, want to make a house out of glass because it, hopefully will win an award for them or something like that. It also needs to be, sort of thought about in terms of future proofing as well. We don't, we will, we'll look at these houses, and it may be, you know, if we've got sort of a 9-year-old that's living with their family and they've got siblings, you know, we'll make sure that we've got somewhere so that they can live with their family and things like that. But then, you know, further on down the line, we might be looking at when that person gets older, they want to be living independently, and so we're going to be, you know, purchasing another house and doing something different at that stage. So yeah, it's really important that those sort of architects and the family really, I guess, understand, you know, what's happening, and we don't sort of, you know, we're meeting expectations and not sort of, you know, over promising and under delivering, because it's really difficult to find the plot or the building that you want to adapt, but it's also incredibly expensive, because, you know, I would say sort of maybe 8-10 years ago, we were spending 450,000-500,000 for adaptations. I don't have a project which is less than 850,000, you know, and on top of that, we've got architects' fees, we've got, you know, other sort of structural engineers, M&E consultants, all of those sorts of things that are, you know, on top of that. So, you know, the last thing we want to be doing is getting it wrong. We want to get it right, you know, and make sure that that money's going into that house and sort of adding value for our client.
It's absolutely necessary to get those sort of different professionals on board, though, to tick those boxes, to make sure that everything structurally, mechanical engineer, everything that you've just mentioned are done in the right way to avoid any disputes further down the line, because that's the primary reason they're here at the moment, is that you avoid disputes, like I said at the outset, to keep the money in the pot so it can be used towards the project and towards the vulnerable person that needs it.
And I think that's kind of the important thing that some employers will kind of miss with these types of projects, is that the contracts, so the construction contract with the building contractor and the appointments with all of the architects, engineers, etc., are drawing a line in the sand at the point that it is signed. Yeah. And so they're agreeing a fee, whether it's the architect fees for doing X amount of drawings, or it's the construction cost for the building contractor to either design some little bits like plumbing or drainage and then build the rest of it. It's all based on whatever information is given at that time. Yeah. So if the architectural drawings or the structural engineer's drawings or the M&E drawings do not include enough detail, or something changes, but the original set is what was included in that JCT contract with the building contractor, then suddenly your fee of $850 can become a fee of $950. Yeah. And that's because they've got to do work slightly differently. They've got to, change things, how they program things on site. So
don't get me wrong, this is quite envisaged. I mean, like the projects like this, although you can front load it and you can get to a place where you can sort as much as you possibly can out so everyone's got clarity outset, there is going to be a moving beast, and there always are going to be variations. It's just having the right mechanisms in place so that if an issue arises or something arises that wasn't envisaged at the outset of the project, it can be dealt with in a very easily manageable process that everyone is transparent.
Yeah. You know where you were at A, so if there's a change to B or C, you kind of know what's happening. Whereas if you don't have that original starting point, it becomes an absolute mess.
Yeah, and a lot of our involvement as well turns into sort of project council, where the project's going along, there might be a dispute, and it's, as I touched upon earlier, you separate that element out from the dispute so that the project can continue. But it's avoiding those matters escalating so nobody does fall out with one another. The project doesn't just go straight into the sand, as it were. So it's vital to have all of that sorted, and the primary reason here is to try and resolve the dispute so that everyone's happy and they can move on and nobody falls out and the nuclear option doesn't have to happen. I
think, again, we're talking about, having everything, all these expertise under sort of one roof, and, these clients are desperate to get into, these adapted properties because they are, they're perhaps living in, really sort of suboptimal accommodation that just isn't suitable for them. So as Adam says, if we get Lizzie involved at the outset, which means that Adam's job is easier, I guess, to sort of ensure that the works carry on, but the dispute is dealt with, and that is, equally as important because we're still keeping everything moving to ensure that we can get our client in.
It's the delays that I find in my experience are the things that irk the client the most, because like you say, they're desperate on a day-to-day basis, living in accommodation that isn't suitable for that child's or the vulnerable person's needs, and they need to be there as soon as possible. And it's just an ever-rolling process where delay upon delay happens, and unless you've got a mechanism to separate that out and actually say, no, we'll sort this at a later date, you need to press on with this matter now, so the project can continue as quickly as it possibly can, then everyone just becomes unhappy. So it's getting everything sorted early on, and if we can separate it out and continue the works, then that's the ideal thing for everyone.
I imagine it's just having those clear expectations and conversations right at the start to make sure that what we want for the client at the end of the day is the thing that suits them the most. And if something does change, obviously you've got huge things from market uncertainty to supply chain costs to even real basic things that can completely throw projects out of whack. So having those conversations, knowing what that process looks like, I imagine is really, really important.
But again, that can be front-loaded into the contract. You can have the force majeure type events or the events that weren't envisaged at the outset of the matter built into the contract, so that if one of those things does occur, then it's catered for under the contract. And you know that, like I say, that they're ever-changing beasts, these projects. There will be variations. There will be unforeseen events that you didn't foresee at the outset of the matter. It's just having the right sort of scheme in place so that if it does happen, then you can resolve it as soon as you possibly can.
Yeah, because a lot of the conversation at the beginning is really about risk management and just trying to work out who's in a better position to take the risk if certain circumstances happen, and how can they be dealt with most efficiently if they do.
Well, we'll leave it there for today. Adam, Lizzie and Louise, I'd like to thank you all for coming on to Legal Thinking and talking all things about adaptations. It's been really, really illuminating. Thank you so much for your time.
Thanks for having us.
Appreciate it.
Thank you.
Thanks for watching this episode of RWK Goodman's Legal Thinking podcast. For more information on our firm's injury expertise, please visit rwkgoodman.com/injury. If you're keen to watch more from the firm, please feel free to subscribe here. Or if you want to watch more legal thinking videos, please follow the playlist here. Thanks for watching.